Never let anybody see you sweat.
So I was born in New York City, and I lived there until I was 8 years old. I realized that I was a much better talker than I was a listener. I don't know what to say, I just don't like what you're saying.
Sorry, Your Honor.
I ended up going to law school at Georgetown, and I was a prosecutor for Janet Reno. I loved it because it was so raw. Were you cheating on her?
Yeah, sure.
Okay.
All rise.
Our show will be a mixture of education, I think you're misreading the law a little bit, and entertainment. My main goal is justice and the law. That's been my legacy, and the legacy I hope to continue into the future with this show.
Grace Liu claims she invited a date on a romantic weekend getaway, but he canceled at the last minute. Dan Collins says he fell for another woman right before the trip and didn't want Miss Liu to be misled.
All right, Ms. Liu, you are suing Mr. Collins for $450 that you feel he owes you for canceling some plans last minute.
Speed dating is a 5-minute micro-interview that compresses first impressions into quick judgments. In this case, both Grace and Dan felt a genuine connection and began dating consistently. Legally, however, a connection is not a contract, and emotions are not enforceable terms. Courts look for clear promises, mutual understanding, and evidence of reliance. When exclusivity is not discussed, obligations remain limited. Here is a question for viewers. When you enter a casual but hopeful phase of dating, should a confirmed plan create a duty to follow through? Or does the lack of exclusivity keep the duty flexible? Share your view in the comments, because that line between courtesy and liability can decide outcomes in small claims court.
Last minute, let me hear from you.
Well, unfortunately, I met Dan at a speed dating event.
A what?
At a speed dating event.
Oh, tell me about it. How did it go? Like, how many people were at the table? Have you done this before, the speed dating?
That was actually my first time giving it a try.
Have you done it since then?
No.
Did you do it that day with friends or you went alone?
I went by myself.
Have you done it before?
Yeah.
Yeah?
Yes, yeah. A few times. I agree. Like the connection is nice in person.
Yeah, that's how we used to do it.
Yeah.
All right. So, went fine for me. So you do the speed dating, and there's how many people there?
There was 15 total.
Okay.
20 male, 20 female.
How long do you talk to each other? 5 minutes?
Yeah, I think it was a 5-minute timer this time around.
Okay.
Yeah.
And then just both of you just start talking out of nowhere. There's no there are no games. There's no questions preset or anything. You both just start talking to each other.
Yeah, and I guess it was something you felt at first sight.
Yes, both of you felt the connection, and therefore you start dating. How long are you dating?
Well, we dated for about 2 months before the trip.
Okay, now tell me about the trip.
So about a month into our dating after the event, we saw each other a couple of times, and we talked almost every day on the phone, and I felt there was something really special going on. So I suggested maybe we could spend a weekend away in Sedona.
Okay.
So Sedona is about 2 hours away by car. And Dan said he was available the second weekend of May. So I offered to book a vacation rental.
Okay, and who was going to pay for that?
Well, we didn't really talk about the details, but I offered to pay.
You offered to book it, but did you ever like run it by him and say, okay, you pay half, I pay half? Like, what was going to be the plan? That you would just eat it? That you would just pay for it?
I had always
Hold
planned.
on 1 second, I'm not talking to you. What was your plan is what I want to know. What was your plan?
Well, since I was, we talked over the phone, and I offered to put it on my credit card.
That's not my question. My question was, what was your plan? Let's say you had gone on this trip. Were you going to say to him, I want half, or was this your treat?
I guess at that time, I was really falling for him. So
Grace upgraded the lodging from $200 to $450 because she believed the relationship warranted something special. That choice speaks to her sincerity, but it also raises a key legal issue: consent to cost. Without a clear discussion, there is no mutual agreement to the higher price. Courts generally avoid imposing surprise expenses on an unaware party. The lesson is straightforward. If you intend to split costs or expect reimbursement, document that understanding. Before you book, align expectations. Here is a practical prompt for the audience. If your partner upgraded a trip without telling, would you feel responsible for the difference? Or would you consider it their gift unless you agreed in advance?
For him, so I felt I wouldn't mind paying for the trip.
Okay. Okay.
Yeah.
And as a matter of fact, when you talked to him about the place you found, that place was how much?
Was $200.
But then you decided to upgrade to a better place.
Correct.
That was costing you how much?
$450.
Okay. And did you let him know that, or you wanted that to be a surprise for him?
So after that, we went on more dates, and I felt, there was something more. And as I said, I was really falling for him, so I decided to.
What do you mean by you felt there was something more?
It felt that I might be meeting, the right person.
Okay.
At that moment, I felt strongly about it.
Okay, we know all about your feelings. Have you ever had a conversation with him to see if he was dating you exclusively?
I was going to have that conversation.
Yeah, that's a pretty important conversation. So did he ever tell you that he was dating you exclusively?
Well, at that time, we didn't say we were dating exclusively.
And were you going out with him every day, or were you seeing him every weekend day? How was it?
So we would go out like 2 to 3 times a week and spend a weekend together. And then we talk almost every day on the phone.
Okay.
Sometimes hours at a time.
So as it turns out, he calls you, or you call him before the trip. How long before the trip did he drop the bomb on you?
Well, I texted him to confirm the trip a week before.
Oh, a week before.
Yes,
okay.
and he confirmed, and he said he was all set to go, that he was really looking forward to it. And then I have the text message right here as the evidence.
Okay, and then when did he say, I'm not going?
It was on the morning of when I was getting ready, and he was supposed to pick me up in half an hour.
Okay.
This is the moment where timing becomes everything. Don confirmed a week earlier, which reasonably led Grace to finalize plans. Canceling 30 minutes before departure removed her ability to invite a friend, recoup funds, or take advantage of any cancellation window. In legal terms, courts often ask whether the breaching party's conduct caused foreseeable loss. A late cancellation after a clear confirmation can tip the scales toward responsibility for the baseline cost. The lesson for everyone planning trips is simple. If you are uncertain, communicate early. Early notice preserves options, protects relationships, and in court it can be the difference between paying something and paying nothing.
Okay, talk to me about that.
So, little context here. Like, I was looking for love, like Grace was. I was at these events and things like that. And again, we're not exclusive. I was not her boyfriend. She's not my girlfriend. So, I'm going on other dates. I'm seeing other people. And at the time that she had texted me and agreed everything, I was all set to go.
Coming up on Justice for the People.
They already made plans that weekend, so I just, I didn't want to go by myself and drive all the way there.
Oh man, if any of my best friends called me and said, I'm heartbroken and I have a house in Sedona, I'd say, I'm your man.
And later,
Describe what your protective gear is.
Wrist pads and knee pads.
Okay, anything else, or that's it?
That's it.
No helmets?
No helmets.
Okay.
Don states that he met another person and felt a strong connection, which created a conflict with the planned trip. The honesty may earn respect, but it does not erase the consequences of late timing. Legally, good intentions do not defeat reliance. Losses. Emotionally, the impact on Grace is clear: disappointment and a sunk cost. The judge will weigh the candor against the calendar. Viewers, consider this. Is it kinder to proceed with the trip while concealing your change of heart, or to cancel once your feelings shift, even if the cancellation is late? Morally, that is a debate. Legally, the focus returns to notice reliance, and whether the other party was left holding the bill.
we're back with a case of Grace Liu, who brought Dan Collins to court over the cost of a spoiled romantic weekend.
That week I ended up meeting somebody, and the connection was really good. I've never felt a connection like that to somebody, and it's actually the woman that I'm with today still. So that connection is carried. And I didn't feel right going on this trip necessarily. I felt like it's not fair to Grace's feelings. I was trying to protect her emotions. So I know that I had a little bit of time to kind of figure things out from meeting this girl a week.
How long before the trip had you met the girl?
So Grace had texted me saying that we had a week until the trip. Is it still good to go? And I met the girl that night. At the time of the text, I was still set to go. That night I met the girl.
Wow, and then that week, Why didn't you tell Grace if you felt that? Because it's not like you knew the girl a long time and then decided to get serious. So if it was so instantaneous, why didn't you just tell Grace, I don't think I should go on this trip? Like, why did you wait until the morning that you were supposed to pick her up?
There was a lot of reflection going on. I was trying to figure out where I was with it. I mean, it's not a rom-com.
Hold on 1 second. I want to hear them. Let the man talk. I really want to hear his analysis. Go ahead.
I've never done this before. I was just trying to, do the right thing and protect Grace's feelings, protect my feelings. It wouldn't have been fair if I went on this trip.
Right, but you must have been leaning towards going because you weren't canceling. Like, if you had any misgivings, don't you think it would have been a better thing to do to just cancel earlier and tell her, look, even if you're not sure what you're going to say to her, tell her, look, something's come up, I can't go, to give her a chance to have friends to go with or to cancel in time. Because there might be a cancellation policy she can take advantage of. But you just gave yourself all the breathing room you needed, and then she ends up eating it. And now, why would he be responsible for eating? I can understand how he's responsible for eating $200. In fact, you did offer to pay that.
I did, actually. She declined, actually, during that conversation.
Because she wanted the whole $450. He didn't even know you'd gone to the $450.
It was supposed to be a surprise.
By the way, what would you have done if you'd gone on this trip? Would you have told her, I'll pay half, I'll pay... How would that have worked?
I was already fully prepared to pay the $200 back before there was even an idea of me canceling. I was fully ready to try and be a gentleman and take care of that. So I would have been... I would have offered to pay.
Well, no. More of a gentleman would be to cancel as soon...
The judge presses the core fairness question. If uncertainty arose midweek, why was there no earlier warning? In contract disputes, courts ask whether the party acted in good faith and whether the other side had a fair chance to mitigate the loss. By waiting until the morning of departure, Dan removed Grace's ability to cancel, reassign, or adjust. Even without exclusivity, a confirmed commitment carries weight. Here the judge signals a measured approach, compensate the foreseeable. Agreed upon costs tied to the confirmed plan, but do not impose responsibility for surprises never disclosed. That split outcome often feels the most just in small claim settings.
Cancel as soon as you met Princess Charming.
Princess
that
Charming.
would be better. But, matters of the heart are complicated, aren't they?
Exactly, yeah. And I was ready to pay. I was ready to do the right thing.
Right. When you told her, I'll pay the $200, what did she say?
So we're there...
Well, first of all, tell me how this goes down. How do you tell her that you're not going to go?
So...
Wait, go ahead. You tell me. You deserve to be able to tell me yourself. Go ahead.
So it was half an hour before he was supposed to pick me up, and he called me and told me.
At least he called you and didn't text you. All right, go on.
He called me that he couldn't go, and I was just,
I'm sure you were very disappointed.
I was heartbroken, and I thought this would be the trip that we would,
Grace describes heartbreak and humiliation. The judge reframes it. This was a 2-month relationship, not an engagement. That perspective matters because courts do not quantify emotional disappointment in cases like this. They look at concrete losses. The line is subtle, but firm. A person may feel deeply hurt, yet only documented. Foreseeable financial consequences are compensable. Viewers, here is a reflective question. Where would you draw the boundary between normal dating risks and recoverable losses? Many will say that sincere feelings deserve recognition. In court, however, clarity and consent are the currencies that matter most when money is at stake.
Have you been to Sedona before? Of course.
No.
You're from Really?
No.
How long have you lived in Phoenix and not been to Sedona? It's my favorite place on the planet.
I guess it was just waiting for the right person to go.
Okay, so you don't go? When he calls you and says, I don't feel I should go, I've met someone else, so now it's a double whammy. Not only do you not get the trip, but he breaks up with you. So do you go?
I was just devastated.
Yeah, but better to be devastated in Sedona. It's beautiful there. You didn't have a friend you could say, oh my God, this guy, this jerk, come with me on this trip. Nobody you could call?
Well, I did call two of my best friends. They already made plans that weekend, so I just, I didn't want to go by myself and drive all the way there.
Oh man, if any of my best friends called me and said, I'm heartbroken and I have a house in Sedona, I'd say, I'm your man, Or I'd go by myself. How old are you?
I'm 26.
26. Oh, youth is just wasted on the young. It really is. I don't think at 26 I'd have gone either.
I just felt so humiliated and
humiliated in front of who? This stuff happens. This isn't a humiliation. You weren't left at an altar. I mean, really, no. I mean that. I know it's heartbreaking or whatever, but and you liked him, but you dated him how long? A few months, 2 months. These things will happen, right? You have to kiss a lot of frogs, okay, before you get to the person. That's how it works, honey. Right? You don't have to put all your eggs in this one basket. I agree with you. He is wrong to cancel at the last minute. I agree with you that he needs to pay because it's his action that stopped the trip from happening. I don't agree that he has to pay $450 because he didn't even know that you had done that. So I can't hold him responsible for ruining a $450 trip when he had only ruined a $200 trip. I'm really glad that it didn't work out differently, that he called you and said, I don't feel I should go on this trip, because this actually means that you can pick him. You see what I'm saying? Mm-hmm. This is a decent person who doesn't want to lead you on anymore.
The ruling lands with precision. $200, not $450. The logic is straightforward. Dan confirmed a trip that Grace initially found for $200. He did not consent to the upgrade, so he cannot be held to that higher amount. The judge balances equities by covering the portion tethered to mutual understanding while excluding the unilateral enhancement. The takeaway for everyone is practical. Document upgrades, discuss cost splits, and share booking details early. Romance can inspire generosity, but legal responsibility follows agreement, not surprise. Keep expectations explicit, and you will avoid expensive misunderstandings.
Anymore. And, so another guy might have gone on the trip, stiffed you with the bill because you were willing to pay it, and then the next week broken up with you, right? And that's not what this guy did, right? So kudos to him, but really kudos to you. Trust your instincts, and, you just get back on the horse, honey, all right? Verdict for the plaintiff, $200.
All rise.
Judge Millian has ruled in favor of the plaintiff. The defendant owes $200.
Appreciate the time that we had. Sorry it didn't work, and as always planned, I will pay the $200, as always planned. I wish you the best.
Thank you.
Coming up.
You are a small business owner because you're charging these people for the classes.
Yeah, first started with donations, but
in your home. What if they fall and they get hurt and they sue you? Oh wait, that's what's happening here.
The program now shifts from a failed trip to a physical injury claim involving roller skating lessons. Destiny Payne says she was encouraged to skate without protective gear, then suffered a hip sprain. Brenda Kennedy denies liability. This case explores two intersecting issues: what it means to run an informal business that collects payments, and where personal responsibility applies when a student is aware of a risk. Watch how the judge examines consent, causation, and whether the alleged advice actually relates to the specific injury. The legal standards may look simple, but the application is very precise.
Destiny Payne claims she got hurt during a roller skating lesson because her instructor told her she didn't need to wear protective gear. Brenda Kennedy says she isn't responsible for the plaintiff's injury.
All right, Ms. Payne, you're suing Ms. Kennedy for $1,350 in medical bills because you feel like your injury was her fault. Talk to me. Tell me what's happening.
Yes, I'm Destiny Payne. I live in Houston, Texas, and I'm here suing my former roller skating instructor for my medical bills and my physical therapy.
How did you two meet?
Over social media.
Okay, so you're a roller skater?
Yeah, I had a bad breakup, and so I got back into roller skating just as like personal therapy, and I got pretty good. So I started taking lessons, I got better, and I started posting myself on social media, just out of my garage though.
And you wanted to, out of your garage?
Yeah, just out of my garage, just regular.
Right, so the day in question, let's talk about that. You tell me what happened.
So the day before classes, I was had a late night. I was at my friend's dorm, and we were kind of skating because my friend is also a client of hers. So we were kind of skating around, and I left my protective gear at her dorm.
Describe what your protective gear is.
Wrist pads and knee pads.
Okay, anything else, or that's it?
That's it.
No helmets?
No helmets.
Okay, go on.
So that day, I was already kind of tired, kind of groggy. I woke up a little late. So I was like, okay, let's just go. So I went, and I was like, oh my gosh, I forgot my protective gear. I can't roller skate without my protective gear. I want to be safe. And Brenda told me you can't make excuses, you have to stay pretty much. You're going to have to trust yourself at some point to skate without protective gear.
Do you ever skate without protective gear?
Now I've gotten really good. I just skate with my wristbands. That's it.
Yeah, I got news for you ladies. You know, all those joints, they gotta last a long, long time.
Coming up,
So did you hurt your wrists or your knees?
No, I actually sprained.
Destiny explains that she forgot her wrist pads and knee pads and that she felt uneasy skating without them. She says Brenda encouraged her to continue. Legally, that creates a question. Was there pressure that removed Destiny's free choice, or was there advice that Destiny could accept or reject? Assumption of risk means a person who knowingly proceeds in spite of a known hazard may bear the resulting consequences. However, assumption of risk does not apply if an instructor unreasonably increases danger. The determinative point here is causation. Would wrist or knee pads have prevented a hip sprain? If not, it becomes difficult to link the advice to the injury.
No, I actually sprained my hip.
Okay, so tell me how the protective gear would have stopped that. Yeah, that's the pickle here, isn't it?
this is Justice for the People with Judge Millian. We're back with a case of Destiny Payne, who blames instructor Brenda Kennedy for a roller skating injury.
You want to wear protective gear because each and every one of those bangs will cost you later big.
Yeah.
You just don't know about it yet.
Exactly.
But all right, so you are a small business owner, whether you know it or not. Because you're charging these people for the classes.
Yeah, first started with donations, but
in
yeah.
your home. What if they fall and they get hurt and they sue you? Oh, wait, that's what's happening here.
Exactly.
So it's never a good idea for you to say, come on, do it without protect. You keep your little mouth shut, and you have a policy that if people are there, they pay you in advance so you don't lose money. All right, so did you hurt your wrists or your knees?
No, I actually sprained my hip.
Okay, so tell me how the protective gear would have stopped that. Yeah, that's the pickle here, isn't it?
Yes, but
Yeah. So what'd you hurt in your hip?
I just sprained it. Like
Okay,
right
and how do you
about
know
here.
that? Did you go to the
I
hospital?
did go to the doctor. I have the physical therapy.
So you had to go to
in the
physical
medical
therapy.
I had, yes, for 2 sessions a week for 6 weeks. It was classes are
But
far
why
away.
is that her fault?
Because she encouraged me to stay, even after I said I don't have my protective gear and I don't feel comfortable.
And how old are you?
20.
Okay. Can you vote for president?
Yes.
The judge emphasizes agency. At 20 years old, Destiny can evaluate risk and decline participation. The court is not dismissing her pain. It is testing legal responsibility. 2 elements matter most. Was there coercion that removed choice? And is there a causal chain tying the instructor's words to the specific injury? Destiny acknowledges she proceeded, despite doubts. That admission undercuts coercion. Next, the injury is a hip sprain, which is not addressed by wrist or knee pads. Without causation, liability cannot attach. The legal principle is clear, poor. Advice may be unwise, but it is not actionable unless it proximately causes the harm.
Yes.
Right. So if someone tells you to do something, do you have to do it?
No.
You still have agency, right?
Right.
You can make the decision, and you did make the decision.
Judge Millian's verdict when Justice for the People returns. This is Justice for the People with Judge Millian.
Did you get hurt right away?
No, this was about halfway.
And
into
then
the
did you
lesson.
sit it out after that?
I did sit out. I was trying to stretch it out. Maybe it was just a temporary thing, but it continued to hurt.
Right.
So I.
This sounds like one of those things. Sometimes it's just one of those things, and someone else doesn't have to pay for it. I still don't think it's a good practice for you to tell people
I stopped.
to. don't you just tell them, hey, your choice, and
I
that's
stopped
it.
lessons altogether.
You stopped the lessons?
Yes.
Why?
Because this happened, Your Honor. It just
Oh,
is
that's just
something-
silly. The people were
were enjoying themselves. You were, although, you know, you are running a business out of your garage, and that's a whole other thing. So, but if you're good at it and you have a skill and people are willing to pay you for it, even if we call them donations, you know, maybe you should continue to do it. Do it in a park.
The judge rules for the defendant. The analysis is methodical, even if the instructor's comment was imprudent. The injury did not result from the absence of wrist or knee protection. The missing equipment was unrelated to the harm breaking. The causal chain? The judge also notes that adults retain the freedom to refuse unsafe conditions. That autonomy matters. For instructors and small business owners, there is a practical lesson. Set safety policies, require protective gear, and obtain signed acknowledgments. For students, the lesson is equally important. Heed your comfort level, because your decision may determine not only your safety, but also your legal position later.
Somewhere else, maybe not your house, but no, I'm not going to find you liable for this. I don't think that anything you said or did caused her injury. I think that we're all adults and we make our decisions. But on top of that, even if making that statement would have made you liable, her injury isn't related to the statement in the slightest. So I'm ruling in favor of the defendant.
All rise.
Judge Millian has ruled in favor of the defendant. The plaintiff's claim is denied.
Today's outcomes offer two durable lessons. First, in the trip dispute, confirmation followed by a last-minute cancellation created responsibility for the original. Mutually understood expense, but not for a unilateral upgrade. Clear communication would have prevented this conflict. Second, in the skating case, responsibility turned on agency and causation. The student chose to proceed, and the injury was not connected to the missing pads. Do you agree with both rulings, or would you have decided differently? Share your perspective in the comments. If you found value in this breakdown, please select the like button. Share this video with a friend who enjoys courtroom analysis. Subscribe for more detailed, high-energy legal commentary. Your engagement helps us bring you the next case with even sharper insights.